I welcome everyone to the webinar. I hope I am audible. Well, as per the format, the speaker has to introduce himself. I am Satya Ranjan Swain, an advocate practicing in Delhi High Court. I am a central government senior panel counsel, and subjects related to criminal law having an economic angle is areas of my interest, and I thank the organizers of this program, Lawyer Suite, my friend Tarbin. Thank you for giving me this opportunity. The topic for today's discussion is laws relating to fugitive economic offenders and contempt of courts and analysis. I will be dealing with the fugitive economic offenders angle, and my friend Advocate Shoumendu Mukherji will be dealing with the contempts of courts. Uh, so the topic is very interesting. Fugitive economic offenders. It is interesting because it is a recent legislation passed in 2018, and secondly, the media has made it interesting by covering Vijay Mallya, Nirav Modi, Lalit Modi, and others. So, my friends, Vijay Mallya lost his appeal in the High Court of London against the extradition, and he was also refused the permission to appeal in the United Kingdom Supreme Court. I can see some of my friends who are from non-law background is also joining in, and I will try to keep it as simple as possible so that it is understandable to everyone. So, my friends, you must have read about the Vijay Mallya case, and the topic is interesting, and so is the Vijay Mallya case. He lost his appeal, but day before yesterday, it was in the news that the British High Commissioner was saying he cannot be extradited unless the further legal issues are involved. Now, what are the further legal issues? It is for all of us to see. But at the end of the day, we are aware that he is declared as a fugitive economic offender. Now, when I say fugitive economic offender, what does that term mean? Fugitive economic offender. There are 6 things, my friend. An individual against whom a warrant is issued from any of the special courts in relation to a scheduled offense, and that person has left India to avoid the criminal prosecution. And being abroad, he refuses to come to India to face the criminal prosecution. Now, there is a background to it. All these fugitive economic offenders cases are dealt under the Fugitive Economic Offenders Act 2018. And the background is, in the past so many years, the cases relating to bank fraud was skyrocketing. In an average, there was 4,500 bank fraud cases per annum. And as per the RBI report, in 2017-18, there was 5,835 bank fraud cases in 2017-18. So it is clear that the laws which were already prevailing, for instance, IPC, Benami Act, Companies Act, Surface Act, Recovery of Debt Act, these were not sufficient enough. Or I can say there was no law to deal with high value white collar crimes. So, my friends, the bill was introduced in the Lok Sabha in relation to the fugitive offender, but it could not be passed because of the disruption. And subsequently, the government brought in an ordinance under Article 123, and then the bill was again brought in and it became an act and was enacted on 21st of April 2018. Now, what was the purpose behind that act? The purpose is to provide for measures to deter the fugitive economic offenders from evading the process of law in India, and by staying outside the Indian territory, they can no longer evade the processes of law. The sanctity of rule of law will be maintained in India, and this act is applicable to whole of India. Now, under this act, there are two things. One, the person will be declared as economic offender, fugitive economic offender, and second, his property will be confiscated. Now, the interesting part is how the person will be declared as a fugitive economic offender. The Act provides under Section 4 that the director or any other officer not less than the rank of deputy director or any officer authorized by the director, if he has reason to believe that the person is a fugitive economic offender, he has to move an application under Section 4 of the Act before the special court, and in that application he has to mention why he feels that this person is a fugitive economic offender. A. B. The proceeds of crime both inside India and abroad, the property which is owned by him, any other property, or let's say the Benami properties, and the list of person who are interested in the properties. These are the things which needs to be mentioned while moving an application under Section 4. Now, the most important thing is attachment of the property, which is provided under Section 5. Section 5 says that the director can attach the property with the permission of the special court. Now, the special court is a session court which is constituted under Section 43(1) of the PMLA Act. Now, there is a proviso to this section also. The proviso says that even without taking the permission of the special court, the director can provisionally attach the property. But when he attaches that property, he has to move an application within 30 days before the special court. Now, once the property is attached, that property can remain attached for maximum of 180 days. It can be extended by the special court, but the most important thing is the person who is entrusted, who is entrusted with this property has the right to enjoy that property. Now, how the person will be declared as a fugitive offender is something that is very important, and I will tell you how the entire process works. Now, after the Section 4 application is moved before the special court, the special court will issue a notice to the person entrusted and will give time to reply. Now, when the special court gives a notice, the special court will specifically indicate a specified place and a specified time where the fugitive offender has to present himself. Now, if that person does not appear, then he or she can be declared as a fugitive economic offender and his property can be confiscated. Now, the question arises, if that person appears, then if the person appears, then the proceeding under this act will come to an end. It will be terminated. And thirdly, if the person does not appear, but his counsel appears, then also the special court has the discretion to give the counsel an opportunity to file a reply under Section 4. Now, after receiving that reply, the court will hear the matter. For instance, if the counsel appears but he doesn't file any reply, then also the court can proceed to hear the matter. But before doing that, the court will ensure that everything is in place and the documents or the instruction is appropriately served to the other party. Now, my friends, the next thing that I wanted to highlight is once that person is once the special court starts hearing and it comes to the conclusion that the person is a fugitive economic offender, the court will declare him as a fugitive economic offender and his property will be confiscated. Now, when I say his property will be confiscated, what property do I necessarily mean? I mean the proceeds of crime, which is inside the country or abroad, the property which is owned by him, or any other property. Now, if the special court comes to a conclusion that the person is a fugitive offender and the property is outside the territory of India, then the special court will issue a letter of request to the court of the contracting party requesting it for execution of its order. Now, from the date of confiscation of the property, it shall vest with the central government with free from all encumbrances. And once the court comes to a conclusion that the person is not a fugitive offender, his property will be released. Now, my friends, these are broadly the things which I wanted to tell you, but I want to with the next 10 minutes, and I will complete within the 10 minutes. I want to highlight 10 major issues in relation to this act. The first and the foremost is there is a criticism that this act shall not apply to the existing cases. My friend, as a criminal lawyer, I can tell you that the criminal law or a taxation law cannot have retrospective effect. We are in an adversarial mode of justice, and no act can be passed which is retrospective in nature. Because in our constitution, Article 20 categorically says it cannot, no law can be passed which will have a retrospective implication. This is one. The second important is, my friend, I told you that there are offenses which are given in the scheduled offenses, which are given in the schedule. There are 54 sections and 15 laws given in that schedule. But in addition to that schedule, there is one important thing, that the offense, the oath of the offense has to be 100 crore or more than that. Now the question arises, what about 50 crore? It is pointed out, what about the cases which are 99 crore? Now, my friends, one has to understand that the intention of the legislature was to catch the big fish. Now, you have to draw a line somewhere. And we do not have the institutional capacity to accommodate all to deal all the cases which are below 100 crore cases. Now, by doing so, when we do not have the institutional capacity, it will defeat the very purpose of the act. Therefore, there is a limit of 100 crore. The third most important thing is there is a presumption of guilt. Now, criminal law, there is no presumption of guilt. There is a presumption of innocence. One will be treated as innocent until and unless he is proved as guilty. Now here, as per section 5, as I told you, the director has the power to attach the property with the permission of the court, and in the proviso I mentioned, the director has the power to attach the property even without the permission of the court. That means there is a presumption of guilt. Now, I have to take your attention. I have to draw your attention that this is not the only legislation where there is a concept of pre-conviction confiscation. This is a new concept. Yes, I agree, but this is not a entirely new concept. There is a provision in Smugglers and Foreign Exchange Manipulators Act of 1976, in which there is a similar provision, and the Supreme Court, in the case of Attorney General for India versus Amrat Lal in 1994, has upheld that provision. And there is a similar concept in the United Nations Convention Against Corruption, to which India is a party. India has ratified that in 2011, and in UNCC there is a provision under Article 54. There is a provision that there can be a conviction, there can be a confiscation even prior to the conviction. So these are the three things. And the fourth thing is another important thing, that is, this act bars the civil court from entertaining, or the civil court has the discretion to disallow the fugitive offender from initiating, continuing, and defending his case. Now, this is also something that is something new, but there is constitutional implications to it. There are different laws which says the jurisdiction of the court or a person cannot be deprived to access of justice. But here there is a clear-cut provision which says that no civil claim can lie if the person is a fugitive economic offender. The next important thing is in relation to the property which is overseas. How do you confiscate that? Now, for that, here I think our government has to work upon, because in order to execute an order which regarding a property which is abroad, there has to be a sovereign understanding. There has to be understanding between two sovereigns. Now, there is a presumption. There is a presumption here that one fine day we will be having this understanding with all the sovereign countries, but till now we have only 30 plus understanding with different other countries. The next thing that I wanted to highlight is the implementation. We have ambitious laws, lovely laws, but our implementation mechanism is not that good. And it is more so when it is relating to economic offenses, because there are different critical business transactions for which the judges has to be equipped. In the judges training session, no specific training is given in relation to handling these cases. But my suggestion is, like in case of France, in France, when many cases of economic offenses came to the court, the France court appointed an economist as a judge. We can try for something like that. We have similar provisions in cases of tribunals. For instance, Central Administrative Tribunal or the Armed Forces Tribunal. We have administrative members who are expert on that field or who have the domain knowledge. So here is also a requirement for bringing in those experts to the court. The second thing can be done is by increasing the age limit of the judges. And the third one can be, we can bring in the retired judges who were already handling these intricate, complex business transaction or the commercial transactions. Now, my friends, there is another issue that is very important is the director has the power to enter any place. It can do search and seizure even in absence of a independent witness. Now, the critics might say that this is a provision which can be misused. But my friends, my humble submission is misuse of a law is not a ground for not having a law. There is a judgment which I wanted to refer, that is Sushil Kumar Sarma versus Union of India in 2005. The Supreme Court categorically said that mere possibility of abuse is no ground to strike down any provision. Therefore, on that line, I hope the Supreme Court will also agree if there is any case filed against the file in the Supreme Court against these provisions. Now, the last and the most important thing I wanted to highlight is the burden of proof. The burden of proof here lies with the director. The director has to prove that why the person is why he believes that that person is a fugitive economic offender, and why he believes that the property are proceeds of crime. But my friends, under section 16 there is a provision of standard of proof, and the standard of proof is not that of the criminal jurisprudence but is of the civil laws, that is preponderance of probabilities, and there is no concept of proving beyond reasonable doubt. And there is a provision for appeal. Any order, any judgment passed by the special court can be challenged before the high court within 30 days. Even after the 30 days also the high court can entertain the cases uh, if there is sufficient grounds, but the maximum limit is 90 days. If 90 days is elapsed, then the court will not entertain any appeal which is filed against the order or judgment of the special court. And the last and not the least, in the conclusion, I wanted to say that yes, this is a ambitious act, and I hope it will help in higher recovery of loans of the bank and the financial institutions. There will be less bad loans. There will be increase in the financial health of the country, and the money supply will increase, and there will be a faith of the investors on the financial system of this country. With this, I hand over to the next speaker. If there is any question, I am not able to see any questions in my system. If there is any question, I will.
On the right hand side, you'll have all the comments and the questions that are coming. Are you able to see?
No.
Okay, I'll just if you want, we can just take one question, then we'll start with the contempt part.
Yes, I can read that. I can read that now. There is one question in relation to the stock market. All right. Yes, as I said, under section 14, the individual can be declared as a fugitive offender, and similarly, a LLP or a partnership or a company can also be affected if the promoter or the key managerial personnel or the majority stockholders or anyone who is having a controlling interest is a fugitive offenders. And the property will be confiscated. And it is something that is very interesting is, if the property of the company is confiscated, the investors will be more interested to know who is the promoter, who is having the majority stakeholders, who are having the control over the company. And naturally it will affect the investment, and the stock market will be affected. And the second question that I can see is in relation to why there was a necessity of having a special act when we have 82 of CRPC and PMLA Act. But my friends, I want to clarify that when it comes to section 82, no property which is outside the territory of India can be confiscated. And under the PMLA Act, only the proceeds of crime will be confiscated. At the same, but in this, but under this act, the proceeds of the crime, the property of the fugitive economic offender, be it inside the territory of India or abroad, everything can be confiscated. So there was a necessity of this act in specifically. Hope I answered all the questions, and there are other questions, but I would like to hand over to my learned friend Shoumendu to deal with the contempt of court aspect. Shoumendu.
Thank you, Satya. Good evening, everyone. This is indeed a wonderful evening that we've all assembled here. And when Tarveen asked us to if we could actually have a webinar, both of us have been used to organizing and hosting webinars for the last 1.5 months or so. So this was certainly an opportunity that we didn't want to miss, and to meet all of you and to address a very relevant topic of our times, which is contempt of courts. Satya has very lucidly and very well explained the Fugitive Economic Offenders Act. And I would just like to address the second part of today's session, which is Contempt of Courts Act and other laws that are connected to that particular subject. So if we begin initially, I'm not going into much of the history because we are all aware as to how writs and contempt started. It started with the British times in the 18th century. The history can be traced back. Coming straight away to contempts of court. If you look at the Contempts of Courts Act, that is 1971. So contempt is of two kinds. One is civil contempt and one is criminal contempt. Civil contempt is mainly caters to disobedience, non-compliance of any judgment or decree or order, any direction that is passed by the court, and anything that is willfully breached. That is called a civil contempt. Like if you haven't followed a particular order, then it tantamounts to civil contempt. Now, criminal contempt is something that is greatly used. It is the impact is even more adverse. Criminal contempt has three divisions to it. First is any publication, whether by words spoken or written, or signs or visible representation, that scandalizes or tends to scandalize or lowers or tends to lower the authority of the court. That is section 2, subclause C, 2C1. That is one. 2 is prejudices or interferes in due course of any judicial proceeding. That if any judicial proceeding is pending at that time, if you've brought out any publication, if you've written something, if you've said something, if you've spoken something, then that amounts to interfering with an ongoing judicial proceeding. And third is you're obstructing justice, you're interfering with the administration of justice in any manner. So these are the three subclauses of criminal contempt. going ahead, generally, what do we mean by contempt of court? What are the general cases, or what have we seen usually in contempt law or contempt jurisprudence? We've often seen some individuals, some people who have made personal remarks at honorable judges, at their conduct, at why they were holding some, as to why they were hearing a particular case, even though they had something to do with it. So something that shakes the confidence of the public in the judiciary as an institution. Now, we all know if in a democratic polity, the entire public confidence in a particular institution goes away, or it is shattered, or it is disturbed, then the institution itself will not have any respect left of it, right? And contempt is not a shield for a judge personally, but it is a shield for the institution they represent, the chair they sit on, right? And the function they exercise. Now, what is allowed? If we have to distinguish between criticism and contempt, then something that is allowed will obviously be a general fair criticism of something, which we can distinguish from contempt as such, any contemptuous remark that is made. So say, for example, if you've mistakenly published something and you were not aware this was something related to an ongoing judicial proceeding, then that you are excused. If you have made such a remark under Section 3 of the Contempt of Courts Act, even if you've published something, but you were mistaken as to that particular proceeding was pending at that point of time, you would be excused and you would be let off. For a decided matter as such, there is no problem if you write something, if it actually falls in that particular definition of interfering with administration of justice, because it's a matter already decided, you will still not be held for contempt. However, even if it's a decided proceeding and you've published something, you've written something, you've said something that again scandalizes, the word is scandalizes, if you scandalizes, because that is how the definition is of criminal contempt. So if you fall under that definition, even for a decided proceeding, you can still be held for contempt. Now, under Section 4 of the Act, fair and accurate reporting of an ongoing matter is excused. You will not be held up for contempt. Fair criticism, as I've already said, under Section 5, fair criticism is allowed. Now, in 2006, there was an amendment made to Contempt of Courts Act 1971, which said that so they inserted truth and public interest as possible defenses to a contempt of court proceeding. So if somebody comes and says today, so something very similar to defamation law. So if you come and say today you've been issued a notice of contempt and you appear before court, and then you say that, but what I've said is actually true. These are the facts, and what I've represented, what I've said is in a way just what has happened, that is the truth. And what I've said is in public interest. However, how you define public interest, how you interpret public interest is something that is a judicial mind will exercise. So if any question is put to you in court, and say if you refuse to answer it, say if you are a party to a proceeding, and if a question is put to you, then looking at the constitutional safeguards that we have, even if you refuse to answer that question, that is not contempt under the definition. So coming to Supreme Courts and High Courts, their powers, where they derive their powers from. So not just contempts of court, there are also 3 entries in the Constitution which refer to contempts of court. One is Article 129. 129 says that Supreme Court is a court of record and has powers for punishing for contempt, right? It is also linked to Article 142, which says that Supreme Court, if it feels like, it can pass any orders to do complete justice in India, right? So there are certain entries also found in the 7th schedule. One is your entry 77 in the union list and entry 14 in the concurrent list. Right? Although the concurrent list powers have not been exercised as such, there are no state legislations that have been passed with regard to contempt. Statutorily, we just have the Contempts of Courts Act, and Supreme Courts and High Court. High Court derives its powers from Article 215 of the Constitution. So high courts have also been given a power to punish for contempt by subordinate courts. So this is interesting. There have been judges who have been actually called out for passing certain remarks against single benches of the High Court. So there the High Court division bench has stepped in, and this was a very recent case about, I think, 2016 or 2017, wherein the division bench of the High Court stepped in and they had to haul up a particular judge of the subordinate judiciary for passing certain remarks. So High Court has powers to even go after subordinate courts if as such. So this power is under Section 10 of the Contempt of Courts Act. So because the subordinate court judge actually passed some remark on the judgment that was passed by a single judge of the High Court. Now, so there are also instances where contempt is committed right at the face of the Supreme Court and the High Court. Say if you've been called to court and there were certain directions given to you, and you say if you're an official of a particular government authority or a government body, and there were certain directions and you refuse to comply with those directions. So then what the Supreme Court can do, in the recent past, Supreme Court has done it. You can be detained in the courtroom premises till the end of the day. That is in a way a punishment which is also given under the Contempt of Courts Act. And also Supreme Court can necessarily also exercise its own powers under Article 129 and 142. Supreme Court is not bound by the Contempt of Courts Act. Contempt of Courts Act generally lays down a procedure that is to be followed. And Supreme Court, because it has a constitutional power that is granted to it under Article 129, so it is not bound by the procedure that is listed there. If Supreme Court wants, it can exercise punishment to any degree that it wishes to, and it can also follow procedure beyond Contempt of Courts Act as well. What the only requirement, as have been listed in various judgments that have been passed, is that the procedure that is adopted by the Supreme Court has to be just, fair, and in accordance with principles of natural justice. So usually what happens is, so there are three ways a contempt petition or a contempt proceeding can be initiated. One, by Supreme Court, it can be initiated suo motu. It can also be initiated based upon a petition by a person, and so that particular petition has to receive the consent of the Advocate General or the Attorney General. Only then you can pass it. Only then such a proceeding can be initiated. Supreme Court. So there are certain rules which have been framed by the Supreme Court. One is the rules to regulate proceeding for Contempt of Courts Act, which is 1975. These rules were framed. So it said that suo motu, Supreme Court can initiate under Rule 3, a petition made by the Attorney General or a petition made by a particular complainant in person. And however, for criminal, so that is for civil contempt, a person can come on his own. In case it is a criminal contempt, then the consent of Attorney General is a must. Attorney General or the Solicitor General. Of course, in states, it will be the Advocate General. However, if it's a Supreme Court, you have to have the consent of these two constitutional posts who have to give the consent. Only then you can come to the Supreme Court. So initially there will be a preliminary hearing, then a notice will be issued to the contemner. If the person, say, has absconded, if the person is not available, he is missing, then Supreme Court or any court for that matter, High Court as such, do have the power to issue a warrant initially. And even if the warrant does not have the requisite impact, it can also issue orders to attach the property of the accused. So there are various powers that are given. If an appeal is to be filed by a person who is aggrieved or against whom a contempt conviction has been given, so that person can file to the High Court, to the bench of the High Court within 30 days and to the Supreme Court within 60 days. The appeal that is filed to a contempt matter. So these are from the lower echelons of the judiciary. If you are moving up, if you are filing an appeal, then. So there is something I would like to address on, which is called the Sullivan Doctrine. So Sullivan Doctrine was developed in the United States. There was a very popular case law, which is called the New York Times versus Sullivan. So this was a principle developed wherein it was said that, see, if you're holding public office, you should be open to criticism. Very well. So what happened therein, there was a police official who had who had probably faced a particular reporting by a particular magazine or a news agency, say the New York Times, for example, as this was the case here. So they carried out a story which the aggrieved police official said that this is not true, and he went to the local district court there, which was the Alabama court. He won the case there. The Alabama court gave him he won damages as well. But when he went to the Supreme Court, that is when this particular principle was developed. And it's called the Sullivan Doctrine. It said that, see, although, yes, if you are aggrieved, but if you are holding a public office, you should be open to criticism. However, even that freedom is not absolute. So in case such a remark or anything that was made which is contemptuous with actual malice or reckless disregard for truth, then such a person can be called out for contempt. So there were certain riders. I will come to the position of India as well as to how we've developed the freedom, how contempt law is made subject to freedom of speech, and no freedom is as such absolute. So Sullivan Doctrine has also been used by the Supreme Court for the very first time in a matter of R. Rajgopal versus State of Tamil Nadu in 94. So there was no blanket freedom. So past instances where contempt action has been initiated. In 1993, if we say, there was a case of illegal mining and the committee that was constituted by the Supreme Court, so they visited that particular site. However, the mine owner misbehaved with those or manhandled those members that had gone to visit the site. So that mine owner was in a way held up for contempt, and after he apologized, he was let off. So in 2015, there was also a case of M.V. Jayarajam, wherein he used a very inappropriate term in Malayalam for judges, and he was handed a 4 weeks prison term. He even refused to apologize, because of which the Supreme Court took serious note. Because as we all know, this is also to bring to to the notice of all the viewers here today, that if you apologize, that is also a way you can actually get out of a contempt proceeding. And if the Supreme Court feels that yes, your apology is unconditional, or you are making it in a very bona fide way, then you can be excused and there will be no punishment that is meted against you. We've seen the cases of Subroto Roy, where in the Sahara matter, Supreme Court issued contempt notices to him for failing to appear before court and even failing to return the monies of the investors. Then in 2002, we've seen Arundhati Roy, the case of Arundhati Roy, where she was held out for contempt and she refused to apologize. She said that, see, whatever I've said is the truth. And she, in a way, made extremely personal remarks at judges. They said, see, so obviously this was something related to the Narmada Bachao Andolan that was ongoing at that point of time. And so initially there was a article published in Outlook. First instance, Supreme Court let her off, saying that fine, we are excusing you. You are a public figure. Your criticisms are welcome. But then again, there was a follow-up demonstration that was held, and that is where she said certain words. She said made some statements, and she refused to apologize for it, for which she was handed. Although the punishment was not major, but that was a case where she was actually punished for contempt for making some very personal remarks against judges. Then we've seen the very highlighted case of Justice C.S. Kannan, who had again made certain remarks against Supreme Court judges. He was called out for contempt. So in the very recent past, in the onset of the last 1 year or so, we've seen certain political cases that have come up before the Supreme Court related to contempt. We all know that Mr. Rahul Gandhi, who was the then president of the Congress party, so he was held up for his contemptuous remarks by the Supreme Court because a political slogan that he was using was wrongly attributed to the Honorable Supreme Court. So the Supreme Court said, see, we never said it. Whatever you have to tell the public, you have to convey to the public what is there in a particular order of the Supreme Court, or what we've said through the words or through the letters of our order. You cannot in a personal capacity attribute something that was never part of the order. So he had to unconditionally apologize. Initially, he said, I regret my actions, but then Supreme Court said, see, regret is very different from an unconditional apology. So then he had to file another short affidavit saying that I unconditionally apologize, and the case was closed. The contempt proceedings against him were brought to an end. With regard to the protests against the Citizenship Amendment Act in say last December or January, Mr. Harsh Mandar was called out for certain remarks that he had made against the Supreme Court. So it was alleged that he was inciting a section of the population against the Supreme Court. He said, probably, I have no trust against the Supreme Court. We can't trust the Supreme Court because Supreme Court in the past has not been looking after certain sections of the public. Therefore, we must take justice in our hands, and justice will be meted out on the streets. The Supreme Court, again, it had initiated contempt proceedings against him, which was heard together with certain petitions that he had filed. But it was alleged that those statements that he made were insightful and provocative. But that proceeding is still pending because that was filed before the lockdown came into being, before the onset of the coronavirus, and that proceeding is still pending. Now, in April 2020, this is a judgment of 27th April. It is the Vijay. This is a very, I think this was probably Justice Deepak Gupta's last judgment that he wrote before his retirement, before Honorable Lordship's retirement. So he wrote, this was Vijay Kurle versus, this was a suo motu cognizance where the Supreme Court took suo motu cognizance of contempt. So a complaint was, some complaint was made with regard to letters that were written by the President of the Maharashtra and Goa Bar Association, as well as the Secretary of President of the Human Rights Security Council. So they made certain remarks against judges of two particular judges of the Supreme Court. I'm not naming them. Mr. Siddharth Luthra was appointed amicus in that matter. So in the judgment at para 44, Supreme Court actually talks about freedom to criticize. So why contempts of court cannot be read in isolation. It must always be made subject to or read together with the freedom of speech that we have under Article 19. So, and at para 44, this is suo motu contempt petition in brackets criminal number 2 of 2009. And at para 44, Supreme Court says that freedom of speech is made subject to the law of contempt. Supreme Court is not saying that we are not open to fair criticism, as we've already addressed in the initial parts of Contempts of Courts Act. However, this is in the Supreme Court's words. I am also accurately reporting what the Supreme Court has said. Supreme Court said, if the confidence of the citizenry in the institution of justice is undermined, then democracy itself will be under threat. The majesty of the institution cannot be lowered. The image of the institution cannot be tarnished. And even today's certain posts in social media, as well as statements that are made online by individuals, which have large following and have an ability to influence certain large sections of the public, have been frowned upon by judges as well. I am not going into details of that particular case. I am only trying to address at this part. I am only trying to link freedom of speech, right to criticize, and what will be held out for contempt. In another case, which is 1996 5 SCC 216. This is DC Saxena versus Honorable Chief Justice of India. This was another case of freedom of expression subject to reasonable restrictions. The Supreme Court said that freedom of speech has to be regulated. Healthy and constructive criticism will not amount to contempt. And however, motives should not be attributed to decisions. One person cannot say that because this judge has a particular background, therefore I feel whoever is writing a particular remark or giving a statement, because such a background of a judge, this judgment must have passed. And so you're in a way attributing motives to a particular judge for having written that order. So that is again scandalizing, and you are obstructing administering the justice. As they say, the majesty of the institution should not be hurt. So you're getting into those very risky, sensitive areas which delineate contempt and fair criticism. Supreme Court has said anything that you make, any remark that you make, should not affect the objective dispensation of justice. That is what the Supreme Court said. So the government has also discussed, and it has posed questions to the Law Commission, saying that can we in a way do away with criminal contempt. So this was also, I think, defamation laws. There were also a discourse or a discussion that happened whether we should do away with criminal defamation. So similarly for contempt as well, there was a request made by the central government to the Law Commission of India asking whether we can do away with criminal contempt. So the Law Commission in 2018 in its 274th report said that we cannot do away, and criminal contempt has a standing in our society and we have to let it remain to be so. Law Commission further added that, see, it has stood the test of time for the last 5 decades. It must have been for some reason that the Supreme Court has not struck it down. So therefore, we cannot do away with criminal contempt, and it has a position in our society. Certain common law nations like Australia, New Zealand, Malaysia still uphold contempt law. So it is not that contempt law has been completely done away with in foreign jurisdictions. So there are certain countries which still have contempt law that is in practice, that is in course. So yes, India is not the sole country which has contempt of law today. Now, just to come to my last section of what I'm addressing here, and it is something that we can always discuss and debate, is whether we need contempt law as such, whether contempt law in our society has any place, has any position. So why I am saying that, yes, we do, contempt law has a place in the constitutional scheme of things, in the judicial scheme of things, because there are times where we go overboard with our criticisms. Often we say that, see, judiciary is the last standing pillar. It is often said that, yes, that is the last pillar of hope. All institutions have been finished, have been tarnished, but judiciary is the last pillar of hope for certain people. We have seen that when Supreme Court gives an order in a particular fashion, there are Supreme Court is credited, it is appreciated for the kind of orders that it gives. However, if for certain orders that it passes, it is again called out and said that no, so we are losing hope in the Supreme Court. So there has to be an objective assessment. Someone can't just today come and say that, okay, because these are my views, if Supreme Court today gives out a judgment that kind of appeals to my senses, to my understanding, then the Supreme Court is good. But if not, the Supreme Court is bad. No, I don't think so. That is what even the Supreme Court through its judgment is trying to say, that you cannot attribute motives to us. Right? What we are doing, what we are exercising a judicial mind. And because specifically today, comments online on social media, whatever the discourse is, say, be on Twitter or be on anything, on say TV debates, the discourse has become so wild that people very often go overboard. It is not that for very particular, very finite instances, people are making criticisms that are extremely vile and are not music to ears. So we can't lose civility in our discourse, in our criticism, right? So even very recently, Mr. Hari Salve had said that he left Twitter because the amount of hate that he received, he had to leave. So to conclude, we can say that, see, you cannot lower the reputation and respect of an institution by calling it by any name that you wish to. You have to respect the chair. You cannot make your criticisms personal. And some sitting judges have been named and shamed in various public posts. That cannot be the case going forward. Everyone can be anti-established. Some people can be anti-establishment. Healthy criticisms is welcome. When judges do press conferences, they are praised. But if judges say 2 lines about maybe a prime minister or a president, they are called out, they are torn apart, and they are criticized, and very very unpleasant remarks are made against them. Right? Today, no side is willing to hear the other side. Justice Sanjay Kaul, in a very recent address that he gave about last week, I think he was addressing the Madras Bar Association. So he said that, see, in spite of varying political ideologies that we have in our country today, there should be ability to convey your points and ideas over to the other side. And that cannot be done by abusing or name calling. There has to be a level of tolerance that is maintained. Now, what if we do away with contempt law completely? It will lead to destabilization of law and order. This is my personal belief. The office of the Prime Minister has been consistently been attacked and criticized. I do not think that the same should happen with the institution of the judiciary, which for many is still a symbol of hope and respect. And if we mistrust every system that is there in our country or in our polity or a democratic space, I think the entire, as a nation or as a society, we will collapse. So if there are no respectable institutions that are left, I think the entire society or the nation will collapse in a way. Justice Kaul also referred to something called "after me the deluge," which literally means that till such time I am there, everything is rosy and everything is sweet and everything is proper. However, as soon as I leave, or as soon as, say, a person leaves an institution, probably he was referring to certain retired justices who've made remarks in the recent past, that as soon as they leave, all the criticisms start tumbling out, all skeletons start coming out of the closet. So in the end, I would just like to say that we all should look to improve the system, not by abusing it, not by calling it with unpleasant names and remarks. And we should all try to improve the system, erase the creases together. And criticism by way of information is certainly helpful, but not in misinformation that erodes the identity and stature of an institution. Nobody is perfect, no institution is perfect, but the gaps that all exist must be filled in a civil manner, which has been seen to be lacking in the last few years. So that is, with that, I think I would like to bring back Satya, and maybe we can take the discussion and the session forward. Satya.
Thank you, Shoumendu. It was a great session, and it was quite informative. And can you see the questions that are there?
Yeah, so I think with regard to content, I'm not seeing any questions. There are, if you want, you can address something that relates to the topic that you covered. So I think there was one question probably you missed out, that was on. So there was, if I could also show the question on the screen. So this was addressed by Mr. Yadav. We can all read it together. That yeah.
Yes, that is what I addressed in my lecture also, that there is a bar, in relation to initiating, continuing and defending the claims. But one has to, yes, there are constitutional applications when the constitution specifically says the right to access to justice cannot be taken away. But in addition to that, what I wanted to highlight is we have to understand the legislative intention behind it. The legislative intention is that if the complete process is carried out by the special court and the person is declared as a fugitive offender and his property is confiscated, now he comes back and says, I want to reclaim all my property which is already confiscated, and he moves to the court, that will be a little, the system that we have built under this act will completely collapse, because the intention is the person who is a fugitive offender should not, a person who is having any who against whom there is any claim under any of the 15 laws that is mentioned in the schedule should not go away and and this is a provision which was enacted only to deter that person. So I think on that note, this provision was brought in. It is for the
So if
Supreme Court at the end of the day to look
so
into the
that's very
constitutional
important.
virus.
Supreme Court. So after all this, see, everything we must respect, and we must respect the majesty and dignity of the Honorable Supreme Court, even with what you have addressed and the part that I covered on contempt. So Supreme Court is something that we cannot let desecrate or get desecrated or get or its reputation damaged or disturbed. So if there are some comments or there are some questions that people would like to, or maybe we can have a short discussion, then most people are most welcome to post. However, I would also like to take this opportunity to thank the Lawyers Wit. Lawyers Wit has also been doing a very commendable job over the last 1.5 months, and they have been conducting very informative sessions with very reputed, respectable senior advocates who've come and addressed. And I would like to thank Tarveen for inviting us today to address all of you. We've also greatly enjoyed this session, and we look forward to many more. Satya, if there is anything else, we can maybe continue, or we can maybe conclude here, as you say.
No, I would also like to thank Tarveen and the entire team of Lawyers Wit for inviting all of us. And
Yes.
I hope the session was informative for everyone who was watching this program. And thank you, everyone.
Thank you very much. Good evening. Thank you. Namaste.
Namaste.